Hi, everyone. Welcome to our webinar. We're glad that you could be here. We're going to be talking about RFEs, what they are and how to respond to them. I'm Evan Law. I have been in immigration law for about 17 years. I used to work for the USCIS Administrative Appeals Office. I adjudicated a variety of cases. The last case type I adjudicated was the EB-1 Extraordinary Ability visa. I was there when Matter of Danisar came out. That's the case that established the framework or refined the framework for EB-2 NIW cases. So I'm happy to be here with you. I love what Manifest basically offers clients, and it's been great being here with Manifest. So I want to get right into RFEs. A request for evidence is basically an opportunity for you to provide additional documentation. I know it's a headache. I issued RFEs when I worked for the government. But in essence, the process is you file the petition with the government. And as the officer goes through the evidence that you provided, a lot of times they're focusing on what are the weakest parts of your case. And that's just the nature of the adjudication process. And so in that way, if you have submitted a lot of documentation, even including things that you know are kind of weaker parts of the case, that kind of opens you up to get a request for evidence, because the officer is going to say, okay, you submitted this, this, and this. That doesn't quite meet the requirements of the classification. And so we want you to submit this additional documentation. So it's not to say that it's, you don't need to have this view that they're likely to deny your case, but think of it more as it's an opportunity for you to strengthen it. There are additional behind the scenes things that may be going on. We'll go to the next slide. Sometimes officers use this as a way to buy time. They are under significant time pressure. They're human. They're reading things and making first impressions of things that may or may not be accurate. And sometimes they're working with imperfect templates, right? A lot of times in the USCIS, there are officers that are being cross-trained. So say there's all of a sudden a lot of EB-1 filings that come in, they can start training officers from other branches that maybe don't have as many petitions to adjudicate. And so in that way, at times we see requests for evidence that that really aren't helpful, in terms of they may ask for things that don't align with that classification. And so I would just say, well, in general, I would say try to have patience throughout that process, but recognize that this is an art of persuasion. So it really doesn't do any good to respond to an RFE saying things like, "I can't believe you are requesting this thing." In essence, you do want to push back when they're asking for things that aren't required for the classification, but in essence, your goal is to try to comply with the request for evidence as much as you can. So there is another aspect of this that sometimes officers, they probably wouldn't admit this, but they might issue an RFE to buy them more time. So in premium processing, they have to make a decision within 15 business days. And so if they submit a request for evidence, that puts a pause on that time frame and buys a little more time. I don't, it's hard to say how much that goes on, but in any event, if you get an RFE, the best thing to do is to not panic, but to just go through it thoroughly to try to respond as best as you can. And in many ways, the officer is really giving you an opportunity to clarify points, to make certain points stronger. So it really can be a good process ultimately for an approval. Okay, let's go to the next slide. Okay, so common triggers for these. For the NIW cases, if the national importance aspect is unclear, or you haven't really convinced the officer that you're well positioned to carry out the endeavor, that can be a triggering aspect of the case. For EB1s, there are several things that can go on here, and I have to probably pull myself back from talking too much about EB1s because there's a variety of ways in which uh, these uh, these cases are adjudicated, and it can be complex. But one of the main reasons for getting an RFE is just that you establish that you meet 3 out of the 10 required criteria, but the officer just doesn't think you've met the complete standard of EB1s, which is that you show that you've risen to the very top of your field and that you have sustained national or international acclaim. So those cases are adjudicated in a 2-part process. After you meet 3 out of the 10 criteria, then it goes to what's known as the final merits analysis. And in the final merits, it's a very subjective view where the officer is just saying, okay, you submitted this evidence, and this is why I think it's just not sufficient to rise to the level that Congress has laid out for this framework. Okay, so that's one way that it may fall short. The other thing is that sometimes there are just omissions. Perhaps there are documents that don't have a certified translation. Sometimes the support letters really aren't that helpful, or sometimes we see that support letters are written by one person, or I remember seeing instances where you could tell the font was different from the 2 people that were collaborating on a support letter. So things like that can also impact the case and require the officer to say, okay, I'm really not convinced that this evidence establishes what you need to. Here's an opportunity for you to correct it. Okay, let's go on to the next one. Okay, so how officers review the case, and this is just from my time working at the Administrative Appeals Office. It's not to say that every officer does it this way, but the fact is these officers are doing the same work over and over again, and you just can't help but compare one case to the next and to get in a routine of going through cases. And so initially when I would get a case, I'll flip through the brief and several parts of the file, and instantly, if you just find yourself already making a judgment call. Like sometimes I would say, okay, I think I'm going to put this over here in the likely approve file. This one, I'll take another half an hour, put it over. That one's likely going to be a denial. I need to go through it further. So there's a lot that can go into this from a preparation standpoint. A lot of times, attorneys or even just self-petitioners will highlight, put in bold certain aspects of a support letter, for example. That I find that highlighting really helps. So I wonder if some people probably don't want to do that because they want a more refined or formal presentation. But at the end of the day, what you need is to convince this officer of something. And so you need to have this sentence jumping out at them if it really establishes a key point in your case. Okay, so we talked about the RFEs sometimes buying time. Sometimes there's this other aspect that comes into play, which is you have an officer and then you have a supervisor as well reviewing your work. And I worked with some officers that were very deferential to their supervisors, and they almost thought, okay, how do I think my supervisor would adjudicate this case? I want to line up with that. Others are very much more confident, and I would say just I don't know, they take more ownership of this is my case, I'm going to do it my way, and unless the supervisor comes back with different insights, they will just go forward with that. But what happens with that is sometimes you get opposing viewpoints. I remember having a few instances in which I was ready to just approve a case, and yet my supervisor said, no, I'd like to see at least these two other pieces of evidence. And one thing to keep in mind is because there is that that collaborative work going on behind the scenes, sometimes it's best to respond fully to the RFE. I had one case that I was about to approve, but my supervisor wanted something else. We issued the RFE, and then the person actually withdrew the RFE. I mean, they just withdrew the petition, and I was so frustrated. I was just like, oh, they were so close to having this case approved. So that's why I say it's best not to think that it's the end of the world. Now, there are instances when it may make sense to just withdraw the petition and start from scratch, but it would be really a good idea to talk through that with your attorney. So the other aspect of this is that, the officers are basically putting together a compilation of their work, right? And for their reviews, their annual reviews, they're going to be talking about certain cases they've worked on and things like that, certain challenges they had and why they felt like they came to the right conclusion. And I will say this even about the leadership aspect of this. When I was at the AAO, the chief of the AAO told me one time he went to have a conversation with an officer, and he said, listen, I'm not saying that the decision you made was wrong, but I'd like to know how it is that you got to where your conclusion. And so they talked through that and basically had the dialogue and then moved on. So there's that kind of supervisory aspect to this. There are other times when supervisors will come back and say, listen, you requested this or that, you focused on this, but that was incorrect. We need to make sure you don't do that going forward. So they're just like was in one of the slides earlier, there's a human component to this. There's a lot of people being trained in different ways, a lot of different experiences the officers have. But overall, the officer is putting together their best effort as what they think the outcome should be. And so they want to feel like if there's evidence that they would like to see, that's why they'll issue a request for evidence in many cases. Okay, let's go to the next slide. Okay, so kind of as I stated earlier, the RFEs can be a good thing. They can give you a kind of some insights into what the officer is thinking. What exactly is the evidence that is missing? And what's unique about these case types is that there's so many different facets to them that what may convince one officer is not enough to convince someone else. And that takes into account their backgrounds, just their experiences and viewpoint overall. But the RFE gives you an opportunity to basically clarify your position, to add additional evidence that you perhaps weren't focused on. Sometimes that's even on sub-issues that you may not have included in your submission. So for example, in the critical role criterion for EB-1 cases, you have to show that you've performed a critical or leading role for an organization that has a distinguished reputation. Well, sometimes people just would take the opinion of, well, clearly this company has a distinguished reputation, so I'm not going to focus on it. Well, if the officer really doesn't feel that way, you may get a request for evidence asking for evidence showing that it has a distinguished reputation. Then this comment I made earlier, that sometimes it's better to refile than respond. This is for those instances when you really feel like they are just coming at you with everything. Basically, so for example, if you get an RFE in an EB-1 case and they say you haven't shown that you meet any of the criteria, and they give you 10 reasons for each one, it just, it feels like there's a lot that you're fighting such an uphill battle to try to convince that officer, it may just be a good time to look at refiling. On the other hand, sometimes the officers really are reaching too much, and this is what I saw at times when I worked for the government as well. As at times when you're adjudicating these cases, you can almost feel the authority of that position a little bit and say, well, I'd really like to see this or this or that. And at times when I would have conversations with colleagues, I'd say, well, I understand that that would be something you would love to see, but that really is not required in the regulations, And so if we can take a step back, there are things that are kind of overreaching, and so I would say just be on the lookout for when you feel like the officers are overreaching, and this is a good conversation to have with your attorney as well. I will say sometimes with this aspect of cases where there's cross-training, sometimes you see aspects or requirements from one case being brought into another. For example, I just was working on responding to an RFE in an NIW case, and several of the things that the officer was requesting were really pulled from an EB-1 type requirement. They really didn't go to the heart of the issue. So that's just something to be aware of. Okay, let's go on to the next one. Okay, so organization is really helpful. Exhibit lists are helpful. You're trying to frame the narrative really well. That first impression, like I said, when I'm flipping through a case and trying to decide, do I think this will be an approval or a denial? If there are things that are, your strongest pieces of evidence are kind of buried and not highlighted anywhere, they're not addressed on a cover letter, that could be detrimental to the case, because especially if the officer looks through it and makes that initial assessment of I just don't think this is likely going to be approved, they may not get to that piece of evidence that would convince them otherwise, right? The other thing is just when responding to an RFE, you do want to be thorough and make sure you address all of the issues. Because one of the challenges that you have is when they have issued an RFE, they've already put a draft together of language that they can reuse when they issue the denial. So really what your goal should be in responding to a request for evidence is to basically make the officer start over and write from scratch, so that they don't have anything that they can reuse from the request for evidence that they submitted. Because oftentimes that language in the RFE is going to say the reasons why they felt like you didn't qualify. And so if the evidence that you provide still doesn't convince them, they can basically reuse that language they have and go forward with it. The other point I'd say on this is just don't dump documents for them. It's not just about throwing things at them and say, go through all this. I know you'll find the answers here. You really want to address what it is that needs to be established and why this additional evidence meets the requirements. So kind of as I mentioned earlier, talking with an attorney to decide how to respond and when it's better to refile, that's always helpful. And I also addressed earlier kind of the tone. I had some instances, well, one in particular in which I did not want to send an RFE, and my supervisor was adamant about it. I thought we were making a ridiculous point on this legal issue. And we ended up sending the RFE with the language they wanted, talking about the language from my supervisor and branch chief. And sure enough, we get a letter back that says something along the lines of, I thought you were senior officers in the government. This is ridiculous, and well, the problem was I felt the same way, right? So I was like, see, I told you we shouldn't have sent that RFE. But what this also made me realize is that this art of persuasion, it's really, you're really not opening yourself up to have a good response when you just come at the officer with a fiery response like that. So you still want to point out their errors and but do it in a respectful way, because your goal is to get them to go towards an approval, to say, yes, my mistake, you did meet the requirements of the classification. Okay, we can go to the next one. Okay, now this is one that I would say is a very important thing to talk through, is tips for avoiding RFEs in the first place. And sometimes with some officers, they may just be unavoidable, especially if you're looking at the instances where they're trying to buy time or some other reason like that. But for the in most instances, what you want to do is basically think of your case as though you're presenting like a chain that they are going to test the strength of it, and they're going to be looking at what are all the weak links of the chain, and focusing on those. And so, and I addressed this a little bit earlier, but so if you submit documentation that you really know is not that impressive, or that really doesn't quite meet the requirements that you know are there, it'd be better to just not submit that, right? And so one of the best ways to avoid them in the first place is to basically present the strongest pieces of the puzzle first. Oftentimes, so with EB-1 cases, the criteria go in a particular order, 1 through 10. Well, not all of the criteria carry the same weight, and so I wouldn't necessarily just go in order of the way they're in the regulations, but I would look at going with, well, what do I feel are the strongest points of my case, the strongest parts of this? What are the things that you would say to someone when they're asking you, what makes you so accomplished? What is it that gives you recognition in the field? What do most people know about you in the field? Those type of things. And by focusing on those, it really lays out the framework so that you can avoid the RFEs. And then this next part is, you really want to connect the dots for the officers. And this is mostly because they have a short amount of time that they're going through your materials. And so when someone writes something very positive in a support letter, you want to have a next sentence that you put in bold that says, this demonstrates that the role they provided was so critical to the outcome and the goals of the organization. It puts that final point on there so that the officer doesn't have to be thinking through everything themselves. Another point I would make is that I think it is helpful to think of yourself as though you're in the position of the officer. What decision would you come to if you were reading this, and you're reading these cases day in and day out? You can't help but compare them to the last person's case that was just amazing in their field, and now you have this case. It's hard as an adjudicator to put that aside and say, okay, now I have a fresh perspective on this person's case and what their experiences have been. But if you can think through beforehand, what would I think about this, these requirements that I know about? Would I say that was sufficient? Sometimes this could go to a discussion about, like, the membership criterion in the EB-1 cases. There's several aspects to that, and so if you're presenting evidence of a membership of something that you just basically pay an annual subscription to have that membership, even though it looks really prestigious, if you know that isn't meeting the full requirements of the criterion, it's best to just leave that out. So that helps you avoid them in the first place. Okay, so we can go to the next slide. Okay, so question that we get as attorneys oftentimes in the EB-1 or EB-2 cases is, when should I file? Should I continue to build up my case with this or not? I'll share an experience I had just so as I was a missionary for a couple of years, and my mission president told me a story that he and his brother went fishing, and they just decided the perfect spot they had set aside, and they just went right in and just threw out their lines and started reeling in the fish. These other people down the stream were like experienced fishermen that were going above and beyond. They were trying to figure out how to pick the best of everything, right? And they took forever to finally just get their line out. And the way it worked out is that my mission president and his brother, they were just reeling in the fish, catching a bunch of fish. The other people were preparing to prepare, and they finally got to it. And by that point, there were no fish left for them to catch. So at some point, you just need to make the assessment of, do I feel like I qualify for this classification? And if so, why shouldn't I go forward with it? It's one of those things that you never really know. You're never really going to know who the officer is that gets your case, or some of the changes that might come down the road. This classification has been around for a long time, both the EB-2 NIW and the EB-1 framework. But there may be times where the wait times change, right? It just really depends. So I think it's helpful to speak with an attorney about where you are. Sometimes we can counsel people on, well, you're really close, you meet 3 criteria, but you probably don't have enough in the final merits analysis to have an approval. So in that instance, we might recommend that they do some more portfolio building or moving towards it. But if you think that this is a classification you can go for, it really does open up a lot of opportunities. The EB-1 cases are the fastest way to obtain a green card in many instances. So anyway, that's one thing that I would suggest is at least consider meeting with an attorney, talk about what your experiences are, what the strengths of your case are, and how you think you can move forward with that. Okay, so that's really what I wanted to convey. I know I've kind of been all over the place, but we can open it up to questions now. If anyone would like to
Yeah.
send any questions in the chat, and
So,
Haley's here to help us with that as
yes. Hi, everyone. Haley here. So, Evan, we're getting a lot of amazing questions throughout the whole webinar. So, I'm just going to read through a few for you and
well.
help
Okay.
you out here. So, one person asked a really great question. Can one piece of weak evidence cause a rejection on their overall case, on the overall case for EB-1A specifically? Do officers ignore weak evidence and still review you based on the other evidences? Does that make sense?
Yeah, great question. So it won't sink your case because oftentimes the officer will overlook it, especially if there's a lot of other strong pieces of evidence. But it's kind of a case-by-case assessment, because if you're looking at, so let's say the officer has already determined that you meet 2 out of 3 of the criteria, and then there's this weaker piece of evidence that's going towards that 3rd criterion. That does put you in a difficult position, because even if the officer felt like some of the evidence was sufficient to give you that 3rd criterion, the weaker part of that might be what they focus on when they get to the final merits determination. And I'll just make one statement on this, because when you're adjudicating a case, you flip the roles. When you're approving a case, we're going to talk about, well, for example, at the appellate level, when we're sustaining an appeal, we're going to put in the strongest evidence first that basically establishes why we think the director made the wrong decision and why the case should be approved. Now, the flip side happens in a denial. When something's denied, the officer is going to point to the weakest parts of the evidence first, because that makes it look to them that they made the right decision. It looks that way to their supervisor as well. And so that's where you can have some pitfalls in some of the evidence that really should have been omitted. It really can play a role. And I learned this lesson the hard way also in appeals when I was in law school. I thought it was best, I did a lot of appellate brief writing, and I thought it was best that we basically argue everything, argue every point that there was to be made. But then I would find certain times the appeals court would come back and they would deny the case only on the two weaker things, and then they wouldn't even address the stronger argument that we had. And I just thought this was ridiculous. So you want to make sure that that you're not giving them some kind of ammunition that they can use in a denial. That, you know, these officers, they're not heartless. At least I don't think so. I didn't meet any ones that were heartless, right? I did meet some that had a very much stricter interpretation of things than I had, but in essence, they really are open to approving the cases that they feel like should be approved. So, okay, that was long-winded. What other questions
Now
do we have?
that was
If
great.
that triggers another one, let me know.
Yeah, let's see. We had a question about, does withdrawing your application impact the adjudication of a refiled case? I actually saw a few questions about how does previous cases, whether they were denied or withdrawn, how will that impact future adjudication?
Great question. And I would say, no, it does not. And in some ways, it actually may be more beneficial for you. And this is where I'm going back to the comment I made about first impressions. I tried my best to have an open mind with every case that I got, but for the times that I saw cases that maybe someone had applied twice for an EB-1 and it was denied, it's so hard to just put that aside and say, okay, there must have been some reasons why it was denied before. I'm not going to hold that against them. And it's not to say that if somebody's case is denied that they can't turn around and get it approved later on. You certainly can do that. But what you risk is giving an impression of, well, why was it, you know, a wrong impression to the officer from the very beginning of leading, you know, going down that road of potentially denying the case. But withdrawing it, basically that can also kind of just be viewed as an acceptance of, okay, perhaps we didn't provide all the documentation we needed, or the strategy we had wasn't right, so we're withdrawing it and going forward. So, you know, in essence, what I'm trying to say is neither one of them is going to make it so that you have an impossibility of getting the case approved. But what I would recommend is basically put your resources toward what you think is most meaningful. And this is really a meaningful conversation for you to have with your attorney, to where you can just have an open conversation where you say, look, is this the case that it looks like we just got a really strict officer adjudicating this? That might be the case. Or is it something where there was an aspect of the case, perhaps a weakness of the case that perhaps could have been presented better, or that might be better developed if they did a little bit more portfolio building the next time around. So those are difficult conversations to have, because you've already put in the time and resources for the first filing. The goal, though, obviously, is to get an approval. And so you really just need to have an open and frank discussion with your attorney as what is the best way forward to get an approval. Sometimes even having gone through the road going down the road the first time can get you to, it almost forces you to build up your portfolio more. And then the things that you learned from that can strengthen your case even for a subsequent filing. So hopefully that helps. In other words, it really depends on the scenarios.
That's why it's important to have a great attorney by your side for sure. So another question, I think this is actually goes off that one pretty well. Someone asked, there are some talks that we should hold off on submitting all recommendation letters. For instance, if I have 8, I would only submit 2 to 3 and save the remaining to be submitted in case an RFE is issued. What do you think about that strategy?
Yeah, that's a great question, and it's certainly one that I've thought about at times. It's hard to know because on the one hand, if you had submitted all 8 and you get it approved right from the beginning, that's a better outcome for you. What I would suggest is basically taking a strategy that kind of is almost like if you look at a lot of sports teams, you've got a quarterback, first string quarterback, then you've got a second string. If the first string quarterback gets injured, the second string is ready to go and he can jump in there. And so if you have 2 pieces of evidence, that the 2 letters of support that basically these individuals are basically highlighting the same aspects of your career, I think it would be valuable to hold one back. Having 2, might help the case in some ways, but you could view that as, this is my second string quarterback. I'm going to hold him out just in case we need to come back on in response to the RFE. Because what you don't want to do in responding to the RFE is come back and submit, 1 letter and 1 other piece of evidence, and then they say, well, you didn't really provide very much, right? And so that really is a challenging aspect of this strategically, because you want to be putting your strongest case forward, but then again, you also want to be able to have something to be able to respond to an RFE. So yeah, I think that's what I would say on the support letters, but still the goal should be always try to get the case approved in a way that you feel like there should be no reason that they should issue a request for evidence. And if you do that, if you have that mindset, then you can respond almost with this subtle messaging, which is, I'm really surprised that you issued a request for evidence, but we're going to take the higher road and not yell at you. And we're going to provide some things and hopefully persuade you that sometimes you may be focused on the wrong issue here or there, but we're providing this, and hopefully that leads to an approval.
I think that's really good advice. Just remembering that the officers are human is such a big takeaway for people. So I'm looking through, we have so many great questions, guys. I saw a question about, are there any trends you're seeing with RFEs or with denials or with approvals in general? We have actually the most recent data on EB-1A and EB-2 NIW approvals on our manifest blog, if you guys want to look at that. But Evan, do you have any anecdotal thoughts on recent trends with RFEs or denials?
Yeah, I would point people to the blog, and mostly I'll just say this, is that you have so many different officers adjudicating these case types and so many different variables from case to case that it's this is a case type that is very fact specific, and so it's not one that the USCIS is continually putting out new interpretations of, okay, everyone be aware, we're now tightening things up on the critical role criterion or something like that. I wouldn't say that. I would say generally over the past few years, the USCIS has made very good improvements. From the time I was working at the AAO, there were certain issues that I think we were being too strict on. There are still certain of those. Perhaps on another webinar, we can talk about the original contributions criterion. That's one that always gets to me.
Yeah.
But overall, I wouldn't say that the trends are going to be something that are really widespread on a similar issue. And so in essence, what I'm saying is the best ways to go about these cases for the EB-1s in particular is to really just have your attorney be aware of what the underlying framework is, just at a really high level, and then how that compares with the kind of the newer interpretations of aspects of the criteria that have come out over the past few years. But as far as trends in general, I don't really see there are major trends happening that way.
Yeah. That's a great, super helpful. And everyone listening, we will send our blog about approval trends and data in a follow-up email so you guys can look at that closer. So another great question, Evan, about EB-2 and NIW. Someone was asking their EB-2 and NIW got denied because USCIS has a high threshold for approval. The reason for rejection was about the threshold, and they wondered if you could elaborate on that. Is that clear, or do we need to ask them for follow-up context on that?
I think I can address that to a degree, and I'll make some comparisons here between the EB-2 NIWs and the EB-1s. Sometimes I'll just make a statement about EB-1s in particular. Sometimes people can run into problems with support letters in the EB-1 cases when the authors of the letters kind of have some language that goes on about the things that they are confident that this individual is going to do in the future. And there's a blurb that the USCIS has that says, for EB-1s, you have to show that you've already risen to the top of your field. We're not concerned about what you're going to do in the future. The flip side of that is when you talk about the EB-2 NIWs, that focus is on what is your proposed endeavor? What is it that you're proposing to do into the future? Now, there is an aspect of that case where it does talk about what you have done to show that you're well positioned to carry out your endeavor. But the EB-2 NIW is a lower threshold in that way from the EB-1 case. And so in essence, I saw some comments here about the subjectivity of officers. The challenge with both of these visa types is that they are subjective. And I guess I'll point to this. So when I first went into the EB-1 case, my branch chief had one of these. And she basically said, the reason why I am drawn to these case types is that there's this balancing of the facts and us trying to land on what is the correct decision with the framework of the law. But because they're so subjective, you really need officers that have an open mind to consider all of the evidence and to basically fairly weigh the evidence and see if it meets the terms. And so there's really not a way to get out of the subjective component to this. With the EB-2 NIWs, a big part of the case is showing that that your proposed endeavor has national importance. Well, something that has national importance today is going to look different than a number of years ago. And so, this type of discussion does have some objectivity to it because we can be aware of, well, what are some of the important objectives for the government? But something can be nationally important, even if the government hasn't put out a directive that says this is important to us, right? And so that's why, I mean, there's really just this subjectivity to it, as well as when the officer gets to the part where they say, now is the person well positioned to carry this out? That's going to be something that they basically look to. What are their experiences have? Does it make sense to me that these experiences have led them to be able to do that? So yeah, I don't really know that there's a way to get around the subjectivity of this, but I will say, and this is one of the things that I used to focus on quite a bit when I worked for the AAO. A lot of times people would file or proceed with litigation from our decisions. They would take us to federal court. And oftentimes the federal courts would say, this is a very heightened scrutiny that is being placed on this. And so the federal court goes ahead and approves that. Granted, nobody wants to go through litigation and all of that, but in essence, what I'd suggest is you just recognize that the subjectivity is going to be there, and you need to do everything that you can to provide as much objective evidence as well as additional pieces of the puzzle that allow the officer to approve the case. And I think this also is a helpful question because it does bring up something that was very impactful for me when I was adjudicating cases, which is the support letters. The times that I read support letters that I could tell were very authentic from an individual, ones that I didn't think 2 or 3 or 4 people had written, and I didn't know who was writing the letter. Though many times those were most impactful for me. And so, but we also live in the modern world that not everyone has the time to just draft a letter. We get that. The officers know that attorneys have put their some of their expertise into helping craft the letters and all of that. But the more that you can provide the officer that basically shows this is authentic, organic evidence that yes, it has been strategically put together by an attorney, but this is what I've done in my career. This is what my proposed endeavor is. This is what I'm passionate about. Sometimes I'll ask clients to say, what would people say about you that they would point to as your most impressive accomplishments? What are some of the things you are most proud of, and all of that? So the passion comes out. There is and this is why this human component to this really can be effective in establishing not only this kind of a objective evidentiary component, but also just the humanitarian side of saying this is awesome. Going back to what my branch chief said when I joined the branch on the EB-1 cases, she said, this is where awesome lives. And our job is to decide, well, what level of awesome have these people gotten to? And it's a very daunting task, right? So, okay, that was a very long answer.
No,
Let me know if
that
you have
was
any
super
follow-up
helpful.
questions on that.
I think a good follow-up is there was someone who asked specifically, how would an officer going through a business plan specific to the IT sector actually judge that it's beneficial and essential for the national interest? And the broader question here that I've seen some other people asking is, how do officers adjudicate on things that they're not actually subject matter experts on? And I'm guessing support letters have a lot to do with providing that context, but it's a good way.
Yeah, that is a very good question. And this also goes to kind of the technicality aspects of things, because you're right, these officers are not experts in the field like you all are. And so, I just want to make a comment of that clarity that really is important to come through, which is in support letters, have people define terms. If you're talking about very technical terms that everyone knows what that stands for, the officer probably doesn't. So spell it out. What is that exactly? And here's what I would say works really well with support letters in establishing these types of things. You have an expert in the field who can attest to why something is important for the economy, for the nation in general, and then point to other objective pieces of evidence that can support that. What are the gaps that you're trying to fill? What is the need that's there? In many ways, the role of attorneys is we're fighting with words. We're trying to persuade people with words. And you look at the word national importance. Well, it doesn't say critical to the national infrastructure, or you know what I mean? It is just a general term. Is this important to the country in many ways? So if anybody is interested in going back to the old NISDOT decision, that's the framework that was laid out before Danisar. And for anybody that is critical of how subjective or how frustrating the EB-2 NIW is now, I would recommend go read the NISDOT decision and then just try to piece together that, because it was very complex. It was a very difficult framework to work through. And so this is a positive that the government has made when the DANISR decision came out in terms of moving towards a broader scope in terms of it's not as restrictive as it was before with NISDOT. The subjectivity is still there, but in essence, this is what makes these case types challenging, is how do you establish that to someone, and how do you establish it to someone who maybe doesn't have a background in IT related things as well. And that's why I would say the more you can get support letters, the more you can show reports or you know, news articles that talk about a certain deficiency in the or a specific need in the US, those types of things help. So in other words, it is going to be an uphill battle on both of these case types, the EB-1s and the EB-2 NIWs. And it's like I said, even a conversation, referring to conversations I had with my supervisor, which actually came out of a conversation when I wanted to approve a case that he did not want to approve, and ultimately we approved it. But his response was, well, any other given officer might have denied it as well. I will say my branch chief was on my side, so that was nice. But
That's
what
great.
other questions are?
This one's quick. There's two quick ones about recommendation letters. One, is there a magic number for the amount of recommendation letters, which I think I can guess your answer on that. And then two, how do we feel about using AI to generate letters of recommendation? Is that something that should be avoided, or is there something there?
Okay, great questions. There's not a magic number, and I will say there were times that I adjudicated and approved cases that only had three letters of recommendation, but they were solid. They were just what I needed to see. And so I would rather see 3 really strong letters than 10 kind of weaker ones, right? Sometimes there's various things that I would say about this. Sometimes you can run into a scenario where your expert who has written the letter of support is so far above the person, you know, who you are in your field and applying, that sometimes that can be detrimental when they say, wow, this person has, you know, 370 citations to their work, and it can almost be problematic when the comparison is among experts. That only happens from time to time. So I wouldn't say you need to really be leery of that, but the other thing I would point to is sometimes people want to submit letters from like CEOs or, you know, people that just have a very strong title beside their name. But sometimes those letters are not all that helpful because they don't have an awareness of what the person has done in their career. So sometimes when you think those letters might help, they actually aren't that helpful. That said, it doesn't necessarily harm the case to include them. Now, I will say this about AI, because we're living in an AI world now, and I was having a conversation with someone recently that used AI to kind of assess a certain aspect of their criterion, and I was blown away with how well it wrote just this paragraph, and so I um I guess what I'm saying is we're living with AI in various facets of our life, and that's not going to change. Um, so what I would recommend is, if you use AI, make sure that you go through the letter very carefully, and still make sure that not only is it accurate, but that there's something that adds an authenticity to it, a personal aspect of it to the letter. But overall, you know, the best letters, which I know are the hardest to obtain, are the ones where you say, you know, where someone just puts it in their own words and says, this is what I see this person has accomplished in their career. granted, they're going to need some insights from attorneys to make sure certain of the legal points are addressed. But I will just make one comment on that. If you can use your persuasion to basically encourage other people to write some original content, even if it's just sending your attorney an email with some of the strongest points in your words, that can really add a powerful component to the case type.
That makes so much sense, and I think that's really helpful advice for everyone. As we wrap up, I know we have a lot of questions still coming in. We will definitely be sharing this recording with everyone. As we wrap up, Evan, is there any final words of wisdom or advice you would want to give to people, especially as they're considering that big question, file now or file later? I know there's a lot of fear right now around RFEs and denials. Any parting words you want to give people as we wrap up?
Yeah, I would really just suggest you kind of take everything that you know about your career, where you are at this point, and if you think that this is an avenue you want to pursue in the next year or 2 years, I would recommend at least having a consultation call with an attorney. It doesn't have to be us, there's a lot of great attorneys that handle these case types. But I would basically say this. Many times people go through life saying, one day I want to write a book. One day I want to run a marathon or whatever. At some point, you got to just jump in and start moving forward. That's, and I say that with all acknowledgement that I started training for a marathon and just decided that was not for me. So, but with something like this, if you feel like you're on a trajectory for this, I would go ahead and move forward with it. See where you are, because that preparation is going to help you either get closer to an approval or basically, inform you to say, I think I'm ready now and can move forward with this. So I would also say just be patient through the process, and it is tedious. There's a lot of aspects of this case that I think are being improperly adjudicated, but I think the government has, like I said earlier, has made good strides going forward. But that said, you still have an uphill climb, but it's not like scaling a mountain or something and doing, that type of rock climbing or something. It's manageable. And I just wish you all the best luck along the way.
Thank you so much for that, Evan. That's really encouraging. Again, everyone, we will send this recording out. I dropped a link in the chat to manifestlaw.com/webinars. That's where you can request a consultation with Manifest. And we also have a special offer on that page if you guys check it out. So thank you for attending this webinar. So we'll wrap it up now. And thanks again, everyone, for attending. And thank you, Evan, for your time.
Sure. Yeah, I think you all have a great rest of your day.
Thanks. Bye.
Bye.
There we go. Okay. Bye, everyone.
Yeah.